Good afternoon, everyone. Welcome to this lecture series on the rules on evidence. This afternoon, we will discuss judicial notice. Let me share my screen. Okay, Rule 129. When you say judicial notice class, this refers to facts which does not or facts which do not need to be proven in court. So what are facts that need not be proven in court? Number one, those which the courts may take judicial notice. Two, those are judicially admitted. Three, those that are conclusively presumed. And four, those that are disputably presumed but uncontradicted. So class, in these four enumeration, the court will no longer be admitting evidence to prove the same because they need not be proved. No? The court will take judicial notice thereof. So what is a judicial notice? Judicial notice is the cognizance of certain facts which judges may properly take and act upon without proof because they are supposed to be known to them. It is based on considerations of expediency and convenience, and it displaces evidence being equivalent to proof. So class, when you say judicial notice, this refers to certain facts which the judges must know or ought to know, no? By reason of expediency and convenience, which is why class, when you say judicial notice, this is something which the judges will automatically take note of and the party need not prove them in court. Now, judicial notice relieves the parties from necessity of introducing evidence to prove the fact notified, and it makes evidence unnecessary. Now, what are the requisites of a judicial notice? One, the matter must be one of common and general knowledge. Two, it must be well and authoritatively settled and not doubtful or uncertain. Third, it must be one which is not subject to a reasonable dispute in that it is either generally known within the territorial jurisdiction of the trial court or it is capable of accurately and ready determination by resorting to sources whose accuracy cannot be reasonably be questionable. So the requisites of judicial notice, the principal guide in determining what facts may be assumed to be judicially known is that of notoriety. When you say notoriety class, this is public knowledge. The test of notoriety is whether the fact involved is so notoriously known as to make it proper to assume its existence without proof. Now, class, there are two kinds of judicial notice. One is mandatory notice and the other is discretionary notice. When you say mandatory notice, this is the kind of judicial notice which the court will always take judicial notice of. So what are they? Judicial notice is mandatory if the facts are: number one, existence and territorial extent of states, political history, forms of government and symbols of nationality, law of nations, admiralty and maritime courts of the world and their seals, political constitution and history of the Philippines, official acts of legislative, executive, and judicial departments of the Philippines, laws of nature, measure of time, and geographical divisions. So if the question being determined or the issue raised in a trial proceeding pertains, for example, to territorial jurisdiction, or for example, the form of government of the Philippines, or what is the Constitution provides, or the geographical divisions of the Philippines, you don't need to present evidence on this matter because these are part of mandatory notice of the court, meaning the court will always and always take notice of these facts. Now, what about discretionary notice? Discretionary, a court may take judicial notice of matters which are of public knowledge, capable of unquestionable demonstration, or ought to be known to judges because of their judicial functions. So you will notice in discretionary notice, these are facts which the judge may validly refuse to take notice of. For example, it is very hard to determine some facts which are of public knowledge because there is no instrument by which you can quantify how a certain information or knowledge can be of public scale. So if the matter or fact to be proven or established in court is of public knowledge, then the court will have the discretion of whether to take notice or to take note of or not. And also if the information pertains to unquestionable demonstration, or the facts pertains to those matters ought to be known to judges because of their functions, then the court may validly refuse to take notice. Now, when you say common knowledge, these are considered as those coming or comprising of those coming to knowledge of men, generally in the course of ordinary experiences of life, or they may be matters which are generally accepted by mankind as true and capable of ready and unquestioned demonstration. So thus, facts which are universally known and which may be found in encyclopedias, dictionaries, and other publications are judicially noticed, provided that there are of such universal notoriety and so generally understood that they may be regarded as forming part of the common knowledge of every person. Now, discretionary judicial notice can be taken off during trial or after trial but before judgment or on appeal. So the requirement, if the court will take judicial notice of a discretionary matter during trial, when the court on its own initiative or on request of a party may announce its intention to take judicial notice of any matter and allow the parties to be heard thereof. So you have to take note that the court can automatically or without a motion take a judicial notice as long as the parties are allowed to be heard thereon. Now, when it comes to discretionary judicial notice after trial, but before judgment or on appeal, there is pretty much the same requirement. No? The proper court on its own initiative or on request of a party may take judicial notice of any matter and allow the parties to be heard thereon if such matter is decisive of a material issue in the case. So the parties will still be allowed to be heard on whether the court can take discretionary judicial notice of a certain information. The only qualification, if discretionary judicial notice may be taken off after trial before appeal, after trial but before judgment or on appeal, is that the matter in which the court will take discretionary judicial notice pertains to a decisive material issue in the case. Now, so we're done with judicial notice. Let us go to judicial admissions. It is an admission, whether verbal or written, made by a party in the course of the proceedings in the same case, which does not require proof. What are the elements of judicial admissions? So class, pag sinabing judicial admissions, ito yung mga nakasulat, isinulat, o sinabi in the course of a trial, no? During the hearing. So kapag ang isang partido ay merong isinabmit sa korte na isang pleading, no, isang written instrument, or meron siyang sinabi during the course of a trial, ang tawag dyan, class, judicial admission. What are the elements of judicial admissions? One, it must be made by a party to the case or his counsel. So it could either be written or uttered by the party himself or his counsel. Second, it must be made in the course of the proceedings in the same case. And third, it can be verbal or written admission. There is no particular form required. Now, let us compare between judicial admission and extrajudicial admission. By the way, class, if a party has made a judicial admission, whether verbal or written, that admission does not need to be proven anymore by the opposing party. Since it is an admission by the party or his counsel himself, it need not be proven in court. Now, judicial admission refers to those made in the course of the proceedings in the same case. Extrajudicial admission, on the other hand, is those made out of court or if made in a court, but it is in a different or other proceeding other than the one under consideration. Judicial admission do not or does not require proof and may be contradicted only by showing that it was made through palpable mistake or that no such admission was made. On the other hand, in extrajudicial admission, it is regarded as evidence and must be offered as such, otherwise the court will not consider it in deciding the case. Judicial admission, class, is conclusive upon the matter, while extrajudicial admission is rebuttable. When you say rebuttable, contrary or countervailing evidence can be presented to prove otherwise. Now, judicial admissions need not be offered in evidence. Since it is not evidence, it is superior as a matter of fact to evidence and shall be considered by the court as established. On the other hand, extrajudicial admission requires formal offer for it to be considered by the court. Class, if admission is considered or in the form of extrajudicial admission, then you need to offer it. You need to offer the evidence before it is considered by the court. Without formal offer of evidence, this kind of admission may not be considered by the court, unlike a judicial admission. Judicial admission is admissible even if self-serving, while extrajudicial admission is not admissible if self-serving. Now, judicial admission is subject to cross-examination, while extrajudicial admission, there is no opportunity for the opposing party to conduct cross-examination. Okay. Judicial admissions may be made by the party himself or by his counsel, again, in the pleadings filed by the parties. So kung ano yung mga nilagay ng lawyer doon sa motion or sa complaint or sa answer, lahat ng inilagay dyan, ang tawag dyan judicial admissions. Okay? It could also be done in the course of the trial, either by verbal or written manifestations or stipulations, including depositions, written interrogatories, and requests for admissions, or in other stages of the judicial proceedings as in pre-trial. Now, for example, what if a party has made a wrongful judicial admission? Now, what if the admission made was erroneous? What is the remedy or what are the remedies of a party who gave a judicial admission? Number one, written admission. File a motion to withdraw such pleading or any other written instrument containing such admission. Third, in case of oral admission, the counsel may move for exclusion of such admission. So the remedy will depend upon the form of admission. In case of written admission, you have to file motion to withdraw the pleading. Or if it is oral admission, then you can move for exclusion of such admission. Now, let us go to the rules on admissions made in pleadings. As a general rule, the facts alleged in the party's pleadings are deemed admissions and are binding upon that party. So whatever allegations or defenses you have propounded in your own pleading, these are considered as your own admission and it will bind you. Now, exception is that hypothetical admissions made by party litigant, as when a defendant moves to dismiss the case based on lack of jurisdiction or sets up an affirmative defenses. So class, for example, there is a ground to file motion to dismiss or motion to quash the information. If a motion to quash the information is filed, there are hypothetical admissions. When you say hypothetical, these facts may not be true as in the case. Kasi class, pag nag-file kayo ng motion to quash, the party will assume as true the allegations in the information. For example, if you file a motion to quash based on the facts, based on the defense that the officer who signed the information has no authority to approve the information filed in court, then by filing the motion to quash, the party will have to hypothetically admit the asseverations in the information, and then the accused will have to ask the court to rule on the basis of this hypothetical admission. Since admission is only hypothetical, it will not bind a party. Now, admissions in a pleading which had been withdrawn or superseded by an amended pleading, although filed in the same case, are considered as extrajudicial admission. So class, halimbawa, nagkamali kayo ng inilagay sa answer or sa motion or sa any other pleadings, pwede niyo siyang i-withdraw. You have to file motion to withdraw. Now, kapag inallow ng court ang withdrawal ng any motion or pleading, then that withdrawn pleading becomes an extrajudicial admission. The original must be proved by the party who relies thereon by formally offering it in evidence. So that is the effect, class. Pag nagkamali kayo sa pleading na isinabit ninyo, sa affidavit na sinabit ninyo o pinresent sa korte, yan ay judicial admissions. Pero kung gusto nyong bawiin, you have to file motion to withdraw. And if the court will allow that pleading to be withdrawn from the records, it will be considered as extrajudicial admissions, and therefore it can be offered and proven by the opposing party as a matter of fact. Okay. Now, let us go to admissions made in pleadings which are not filed with the court. If signed by the party litigant himself, it is considered as extrajudicial admission, while if signed by the counsel, it is not admissible because a counsel only binds his client with respect to admissions in open court and in pleadings actually filed with the court. So these are pleadings which are not filed in court. So pag hindi pa na-file yung affidavit or motion at may pirma na ni party litigant, extrajudicial admission yan. Kung wala naman pirma ni party litigant, ang may pirma si counsel, hindi yan extrajudicial admission. Kasi the representations of a counsel will only bind his client in open court. Now, when admission is made in open court. Okay? Now, class, what is self-serving evidence? Ano ba yung tinatawag na self-serving evidence? Self-serving rule which prohibits admission of declaration of a witness applies only to extrajudicial admissions. If the declaration is made in open court, such is raw evidence. It is not self-serving. It is admissible because the witness may be cross-examined on that matter. So class, for example, ang testimony ng witness is that nakita niya ang defendant na nag-issue ng cheque na later on tumalbog. Now, that declaration of the witness is self-serving. Why self-serving? Because it will be in the furtherance of his intentions or motives. It will be favorable to the case of the complainant. Now, if an evidence is self-serving as a general rule, it will not be admitted in court. However, class, if the evidence is made during trial in the course of the proceedings, then it is not considered as self-serving because the other party has the opportunity to conduct cross-examination against the other party. Now, how do you contradict a judicial admission? It can be done through by showing that it was made through a palpable mistake, that there is no such admission made, or to prevent manifest injustice. Now, let us go to judicial notice of foreign laws. Yung mga batas ba sa ibang bansa, class, meron ba yung judicial notice? Foreign laws may not be taken judicial notice of and have to be proved like any other fact. So pagka ang batas ay galing sa ibang bansa, hindi yan judicial notice sa Pilipinas, except when it is well and generally known, it was actually ruled upon in other cases before it, and none of the parties claim otherwise. Now, with regard to ordinances, the municipal trial court, the first level courts, are required to take judicial notice of the ordinances of the municipality or city wherein they sit. Now, the regional trial courts or the second level courts can take judicial notice only when expressly authorized to do so by the statute, or in case of on appeal before them, and wherein the inferior court took judicial notice of an ordinance involved in the same case. Now, appellate courts may also take judicial notice of ordinances not only because the lower courts took judicial notice thereof, but because these are facts capable of unquestionable demonstration. So this ends our presentation. I'll see you again next meeting. Thank you.